And welcome to Houston Newsmakers Extra, where I'm continuing my conversation with Professor Emily Berman from the University of Houston Law Center. Professor Berman, let's talk about what I perceived, and a lot of people have perceived, about the Republican strategy of kind of pushing the envelope in the Supreme Court a bit, because there seems to be, the Supreme Court seems reluctant to overrule decisions that have been made by state legislatures. Is that correct? Am I seeing that correctly? Is that what's happening around the country, you think?
Yeah, I think that's true. I think the Supreme Court has shown itself quite reluctant to second guess what state legislatures decide they want to do with respect to elections. We've seen it in the redistricting context, where the Supreme Court decided we're not going to get involved in those cases. That's a political question. We're going to leave it up to the political parties in the states to decide how they're going to redistrict and whether or not a state is too extensively gerrymandered. Just last term, there was a case under Section 2 of the Voting Rights Act, the laws that are racially discriminatory, and plaintiffs challenged a couple of laws that had been changed in Arizona. And in a 6-3 decision, the Supreme Court said, Arizona's laws are fine. Yes, they might incidentally have an adverse impact or a disproportionate impact on minority voters, but all in all, they don't make it too hard to cast a vote. And besides, the justification that the state put forward is that they are protecting against voter fraud, and that's a legitimate state interest, and so we're going to go ahead and let the state's rule stand. So when it comes to what states have done, the court has been quite willing to accept the justifications offered by the states, whether or not there's evidence. For example, with the voter fraud, there's little to no evidence that that's a real problem, and yet discounting evidence that there will be a discriminatory impact on minority voters.
So as we look at the courts, a lot of times it looks like, and you talked about it earlier, about on the program, we're talking about how it seems like a court is leaning one way or another, to the right or to the left, progressive or conservative. Whatever the reality, perception plays a huge role in all this. And how is partisanship shaping, you think, how this court is being perceived? And do you think the court really cares? The justices are there for life. They don't have to worry about, being term limited or anything.
Yeah, so they are concerned, and they should be. So at the end of the summer, you had several justices speaking out publicly, sort of defending the independence of the court and arguing that it was a nonpartisan institution, and trying to combat the perception that they are in fact just a super legislature of 9. And one of the reasons they have this concern is their legacy. And in particular, Chief Justice Roberts has shown himself to be quite sensitive to the perception of the court as an institution and its institutional standing in the United States. So one concern is their own legacy and reputation. But there are also more potential concrete repercussions. So we've seen ideas bandied about with expanding the number of justices on the court, or imposing term limits, or some real concrete steps that would curtail the power of the court. First-year law students, the court only has as much power as we're willing to give it. It doesn't have its own army to enforce its decisions, and so it has to act in a way that we, the people, are willing to accept it as the final arbiter. And that concern about losing its legitimacy is something the court always needs to have in the back of its mind.
Throughout the years, I think people today hear the Supreme Court decisions and they say, yeah, okay, wow, that makes sense, or doesn't make sense. But I've seen examples in the past where the Supreme Court has stepped in and made rulings that today we look at and we say, what? How could they have done that? One of the cases I think we talked about was a black man in Alabama who said the state law was unconstitutional and why it didn't allow him to vote. And the Supreme Court kind of said, yeah, well, it's kind of too bad, ultimately. And that's kind of one of those decisions that's kind of eye-opening, is it not?
Yeah, there are a few of those scattered through history. I think a lot of people, when they think of the history of the court, they think of things like Brown versus Board of Education that really expanded individual rights, or other cases upholding the rights of racial or religious minorities or women or people based on their sexual orientation. But for most of its history, the court has really not been a force for social justice. And it's more often the interests of sort of the haves against the have-nots. So in that case from Alabama, you mentioned Alabama refused to register African-American voters despite the existence of the 15th Amendment that prevented that. And the court essentially said, well, as long as that's what the majority of the people in Alabama want, there's nothing the court can say that's going to change that. And there's a series of cases through the Reconstruction era that follow along in that same sort of blueprint, where it seemed as if the law on the book would protect minority voters and protect them from violence. The court made these sort of tortured interpretations to avoid reaching that conclusion. So it's not always been a force for expanding rights. It's often been a force for contracting them.
Let's talk about Roe versus Wade. I mean, that's something that's been on the books for a long time. And I know the court now, court watchers who look at it now, they seem to think that the way the court is structured, that it's a foregone conclusion that that would be overturned. Do you believe that as well? And how big of a deal would that be, since it would be overturning something that's been recognized as law in this country for so many years?
Yeah, it would be a big deal. And I do think Roe v. Wade's days are numbered. I'm not sure that this term the court will write the exact words Roe versus Wade is overruled, but they will constrict the right to safe legal abortions in a meaningful way. I think most court watchers would be shocked if that were the result. And that, of course, is a huge issue for women who have relied on the availability of abortion in making decisions about their lives. But it's also going to be the first time in a long time, maybe the first time ever, that the court has overruled a prior case in order to constrict individual rights rather than expand them. So Brown versus Board of Education overruled Plessy versus Ferguson, saying, no, segregation is actually not okay. We need to integrate the schools. Obergefell more recently said, no, states, you're not allowed to limit marriage to heterosexual couples. You have to allow same-sex couples to marry. So usually courts, when they're overruling prior precedents, are doing it in a way that expands rights. So for the court now, for the first time, to retract rights that have long been recognized as fundamental in America, I think that is a dangerous step, and it's a pretty chilling prospect to me going forward.
Professor Berman, thank you so much for your time today. It kind of makes me want to go and take your class, but I'm afraid to fail. So that would keep me from doing it. I mean, I'm good for these little quick interviews, but having to take a test, I might not do so well. But thank you for your time. We appreciate it. And good luck as you instruct the law students of the day on what they should do to protect rights and do the right thing through the years to come. Thank you, Professor. Appreciate your time.
Thanks for having me.
All right.